Good evening, and welcome to the July 2015 Richardson Law Office's Legal Hangout. Today, this month, we're continuing our discussion of creditor harassment in New Jersey. In my bankruptcy practice and my collection defense practice, I've talked to a lot of people that are having a great deal of difficulty with debt collectors. It creates a lot of stress, a lot of problems. It drives them to my office because they want to know what can they do, how do they deal with all these collection calls and letters and that sort of thing. And what I try to advise them, and what I want to talk about today, is some of the things I tell them when they're in my office to talk about these claims by debt collectors when they call or send letters, that sort of thing. And I want to talk about, last month we talked about some other tricks that debt collectors can do that can get them in trouble under federal law and state law here in New Jersey. But there are other things they do. A lot of times, because being a debt collector, that's a high-stress job. Most people end up in collections, not because they simply don't want to pay the debt or don't feel like it, but because they've encountered a job loss or a drop in income or illness or something that is interfering with their ability to pay the debt. So there's a good reason why they haven't paid. So these debt collectors are trying to collect from someone who, if they had the ability to pay, would have already paid. And of course, each one of them is in competition with another debt collector who's trying to collect another debt to try and get their debt paid first before somebody else's. And also, they're increasingly over the last few years, creditors, instead of sending the claims out to a debt collector, they sell them because they know like I said, a lot of people are not paying, not because they're just refusing to or they're deadbeats or whatever, but because they simply can't. Job loss, illness, whatever. Divorce can often create that problem because it increases expenses and makes it difficult to live on current income. So instead of trying to collect it, which can be very difficult, very stressful, they simply sell it off for literally pennies on the dollar a lot of times, depending on how old the debt is. And how collectible, and they figure, well, we'll get some money and we'll let the debt buyers worry about it, and that creates a whole host of problems both for you and for the debt collector and for that debt buyer sometimes, which we'll get into in a moment. Let's talk about how we need to deal with some of the desperate tactics and misrepresentations that debt collectors can use to try and collect money from. Now, they can misrepresent things. Now, it's not only an intentional misrepresentation of fact, but a sin of omission. If they leave out a key fact, that can create a problem. So, among the things that they can't misrepresent, they can't misrepresent the character, amount, or legal status of any debt. Now, the character of the debt, well, is it a credit card debt, is it a medical bill, what is it for? The amount, well, that can come into play. Because say this debt buyer, they've bought this old debt, and a lot of times they'll have maybe a name, an account number, a balance. They'll have very little information about the debt when they try and collect it. And a lot of times they'll add on money to it. Not only the face value, let's say they bought a $3,000 credit card debt for 10 cents on the dollar, and then they turn around and added some fees or interest or whatever they want to add on that you may not be responsible for under the original credit card agreement. And they just add it on into the total. So simply by quoting a balance to you, by saying you owe X dollars, they're making a misrepresentation of fact. So, and they can't do that. The amount of the debt, When you are faced with that, when they say you owe this amount of money, well, ask them. Wait a minute. How'd you come up with that number? Where did that come from? What is it based on? A lot of times they don't have that information or don't want you to know. They're just there to try and collect the debt from you, and this is the amount. Now, the legal status of the debt. That can be a big misrepresentation. Maybe it's just too old. New Jersey statute of limitations is 6 years for credit card debt. Now, sometimes the statute of limitations can be based on the state under which laws the credit card agreement or the loan or whatever is based, or where the creditor is based. So if they're based out of Delaware, for example, Delaware has a shorter statute of limitations, and some other states have longer. So we're talking, when I say 6 years, I'm talking about New Jersey, although that statute can change. But the point is, it might just be too old to collect. The reason why that creditor sold it is because it's past the statute of limitations. They're never legally going to be able to collect it, so they might as well get whatever they can for that debt. So if it's past the statute of limitations, they can't misrepresent that. And if they were to sue you on that debt as past the statute of limitations, then that's a violation of the Federal Fair Debt Collection Practices Act, which is the federal legislation I mentioned last month that protects you from debt collector harassment. Maybe they bought a debt that you discharged in bankruptcy. Remember, they're buying some old debt. So let's say you had, and just to pick a name, nothing against this particular creditor or bank, but let's say you had a Visa card with Bank of America, and you filed bankruptcy in 2008, and this debt then gets sold, and it gets sold to a debt buyer. They turn around and try and collect it. And you're like, well, who the heck is this outfit? You know, ABC Asset Management or whatever they're called. And they're a debt buyer and they bought it, but it's been discharged in bankruptcy. So if they misrepresent that at all, and just by trying to collect it, they are misrepresenting that fact to you because it's a sin of omission. They're not saying, oh, we have this debt, but you discharged it in bankruptcy. You don't really have to pay it. All right, they leave out that part. They say you owe this money. Well, you don't. Bankruptcy discharged it. So that's a fraudulent misrepresentation of the legal status of the debt, and they can't do that. So that's another one of the lines that they try. Any compensation which may be lawfully received by any debt collector for the collection of any debt. That's what I was talking about earlier. They may add on fees or interest or that sort of thing, attorney's fees, and they may not be entitled to that. The original agreement you had for the loan, for the debt, it didn't include attorney's fees. And now they're saying, oh, you have to pay attorney's fees. Well, no, they can't. They can't misrepresent that. Here's a good one: misrepresentation of fact. I said, what will happen if you don't pay? Well, naturally, they want to create this atmosphere in which horrible things will happen if you don't pay this debt. One of them is you'll go to jail. Well, folks, there has been debtor's prison in this country for a long time, and that's why we have bankruptcy laws. There is no debtor's prison. You're allowed to get your debts forgiven every certain period of time. In Chapter 7 bankruptcy is once every 8 years. So there is no debtor's prison. So they tell you that you can go to jail if you don't pay. Then that's a misrepresentation of fact. So they may create these dire circumstances of what may happen if you don't pay. So that shouldn't happen. They can tell about the seizure, garnishment, attachment, or sale of your property or wages unless you pay. And this is another one. You know, if you don't pay today, by Wednesday, on Thursday, we'll garnish your wages. No, they won't. You know, only the federal government and certain federal government agencies can do administrative wage garnishments where they haven't sued you first. So if they're ABC Asset Management Company, or if they are XYZ Bank on a Visa card, they cannot garnish your wages unless they brought suit first. So, and misrepresenting whether or not that creditor is ever going to sue. Now, sometimes there may be a small balance, maybe a few $100s that they're looking to collect. It may, and I'm not saying necessarily with a debt buyer, but with any debt. Okay. Sometimes medical debts, there may be some fairly small doctor bills and things like that. And it's a lot of money that's not worth suing on. Okay. And they'll say, look, you know, if you don't pay, we're going to sue you, we're going to get a judgment, and we're going to attach your wages. Well, that may be true from a legal standpoint, that if they sue you and get a judgment, they can then attach your wages under certain laws in New Jersey on how wage executions work. But if the creditor has no intention of bringing suit, then that's a misrepresentation. They're never going to sue you. They're just lying about suing you. And that's a misrepresentation of fact. So, again, anything to create pressure. Again, false misrepresentation or implication you committed a crime or other conduct that may disgrace you. Sometimes bouncing a check. They may get you to send a post-dated check. And then when that check doesn't clear, they say, oh, you're check kiting, you know, you can go to jail. Under New Jersey law, post-dated checks are just promises to pay. They don't come under the check kiting statutes. And even if you made a payment to on this debt and it didn't clear, it's still not check kiting. And now again, we're talking about New Jersey law, folks. So if you're not in New Jersey and you're dealing with creditors outside of New Jersey, your state's laws may be different. But in New Jersey, check kiting is basically a situation. Let's say you go to the supermarket and you get into the checkout line and you buy all this food and you write a check. Well, that check then bounces, and the supermarket comes to you and says, look, your check bounced. We want you to replace that check with cash within the next 10 days. And if you don't do that, if you don't replace it with cash in that 10 days, it creates a presumption that you never intended to pay for the goods. Right? So number one, you're dealing with a contemporaneous payment by check for goods and services. They sold you the goods or rendered the services based on your tendering that check, and that check didn't clear. Or a currently dated check, not a post-dated one. That's where check kiting comes in. And the mere fact that it bounces isn't enough, because if you pay within 10 days and make good, it's fine. And even if you don't, it just creates a presumption that you never did. You still have a defense. There may have been a very good reason why you didn't replace that check within 10 days. Let's say the check bounced and then you left for a 2-week vacation. And they send you a letter saying in the next 10 days you've got to pay. Well, you get back from vacation, 10 days are passed, and you're looking through your mail and you see this letter. Creates presumption. So it's another trick that people have, that debt collectors can sometimes use to get you to pay, to scare you. So that they can try. I think I mentioned last month about calling other people, neighbors, family members, and basically trying to embarrass them and humiliate you into paying. These are the things that they can't do. So, how do you defend yourself? How do you deal with these debt collectors? What do you do to protect your rights and to make sure you don't fall into some of these pit traps? Now, I could go on for hours on this. I mean, I'm just trying to give you a general idea, so don't take this as an exhaustive list. But debt collector calls, ask them for the name of the company, the name of the caller, their address and telephone number. They have to give it to you under federal law, and it has to be accurate. Now, sometimes, to protect your own privacy, debt collectors will sometimes use pseudonyms or maybe just give you their first names. But as long as you're ultimately able to identify that employee when it comes right down to it, that's okay. But they really have to identify themselves, who they are. And one good tactic to defend yourself is that you get a good telephone number. Is it, where can I call you? Let me look into this and call you back. Where can I get a hold of you? Okay. If they don't give you a telephone number, that's a big old red flag. You know, they could be out of state, they could be working in a trailer somewhere, you just don't know. But a reputable debt collection agency will be able to give you a telephone number, or even to call back that same person. Let me get an extension. Give me your extension number so I can call you, if that's possible. Then if you do call them back, and again, this is for New Jersey now, if you're in New Jersey and you're calling them back, find a way to record the conversation. You hear those, and if you hear them say, this call may be recorded for quality assurance, what they're really doing is complying with some other states' laws, because when you record a conversation, state laws can vary. So, for example, in some states, you can't do it unless all parties to the conversation are aware that it's being recorded. So in order to comply with those laws, depending upon what state they're calling, because sometimes states like New Jersey, for example, as long as one party, you, know it's being recorded, that's enough. But not all states are like that. So they do this, recording the call for quality assurance. Make a note of that, okay, because you may later want to ask for a copy of that recording. Call them back, record the conversation, you're calling from New Jersey, because if they make a verbal misrepresentation that violates the law, you protect yourself, because now you have a recording of that conversation. What creditor do you represent? Who is this debt supposedly owed to? And find out. If you don't immediately recognize it, say, did this person buy a debt? Is this a debt buyer? Who is the original creditor? Okay. Find out that. And the even better way to do it, ask them on the phone for a verification of debt. All right? You ask them for that, they have to give it to you. And as part of that verification of debt, if they are not the original creditor, they must identify the original creditor. And since you're getting their address as well, do it in writing. Request it in writing so you have a record of it. And I would send it by certified regular mail so you can show that they got it. Because oftentimes, if this is the first time they've contacted you, and they have to tell you that you're entitled to a verification of debt, that they can't contact you again until they've provided that verification of debt. So they're required to provide you with this information upon request. So document the request and make sure they fulfill it, because if they don't, well, that could be another violation of the law. So another part of when I say that, well, can I call you back? One thing you want to do is pull all three of your credit reports, okay? All three of them, and take a careful look at it. Is this creditor that they've identified listed? They may not be. They may have not properly bought the debt. They may not have reported it on your credit. And if they are a debt buyer, they have to identify the original creditor. If that creditor isn't listed, then it may be because it's more than 7 or 7.5 years old, and under the Fair Credit Reporting Act, it's been dropped from your credit. Well, if it's that old, it's past that 6-year statute of limitations. So that may be another big old red flag that there's a problem here. Also would indicate if they're a debt buyer, so you want to find out how old that debt is. So pull the credit report and take a careful look at it. Also, whatever you do, don't don't send them any kind of payment or partial payment. Okay, if it's an old debt, if it's past the statute of limitations, if you send them a payment, they can argue for the resetting of that statute of limitations. So you want to make sure that this is a valid debt, and you maybe talk to a collection defense attorney on this debt, and have him or her do a little bit of investigation, maybe negotiate on your behalf, so that you don't end up paying a debt that's too old, that can't be collected, and partial payments could cause a problem with statutes of limitations. A couple other things to bear in mind. I talked about bankruptcy and statute of limitations as far as the legal status of the debt. A lot of debts are being sold and packaged together, thousands and thousands of accounts being sold in bulk to these companies. And a lot of times, they're not paying attention, not providing enough information. They may have the wrong name. It may not even be your debt, but they're claiming it's your debt. Or that debt, you may have paid it years ago. You paid the debt, but now they're trying to collect it again. Or maybe you compromised. Maybe you made a deal with the original creditor bank. You talked to XYZ Bank, and instead of on a $1,000 account, they sold it. You paid $800 to satisfy the account. Well, that left a $200 balance that maybe they sold to a debt buyer. And now that debt buyer is trying to collect the whole $1,000 again. So there can be mistakes. People have been known to end up paying a debt again that maybe they don't even owe because they got the wrong person. It may have already been paid, may have been discharged in bankruptcy, may be too old to sue on. But guess what? If they do go to a law firm and they sue you and you get a judgment because you never disputed it, then they win. It doesn't matter about statute of limitations. It doesn't matter about whether you paid it before. They've got a judgment now that says you owe it. Okay? So you need to challenge them. If you've got these types of lawsuits, you should talk to a New Jersey attorney and find out what your rights are, whether there are defenses, whether there's something that you can do. Because at the very least, if you don't know it, and they don't have a claim or they can't prove it, maybe they don't have enough paperwork to prove their case in court if you challenge it. Maybe they can't even prove that they bought the debt or that it's yours. All right? So they may have some proof problems, they may have some other procedural problems under our court rules or evidence rules. So you may have some defenses. Don't assume that you don't, and don't ignore it. If they've brought suit, then if you do nothing, they win because they get a judgment. Statute of limitations is an affirmative defense. If you don't assert it, it doesn't make a difference. The court is not going to bounce it. So you need to do that. If it was discharged from bankruptcy, you need to point it out. If they've identified the original creditor and you've never heard of that creditor, whether it's not on your credit report because maybe it's too old, or you just never had an account with them, don't let it go. Challenge it. It's what due process is for. And if they have violated the act, if the debt collector has violated it, or if you have a debt buyer that bought it out of default, they're subject to the Fair Debt Collection Practices Act, and they can assess damages. And the beauty of it is you can obtain damages out of actual damages. For example, if they repeatedly called you at your job to the point where you got fired, you got lost wages, things like that, or you made some payments to them, maybe you paid a couple thousand on it, and they sued you for the balance, and they never had the right to sue, or there's some other problem. Well, that money you paid them is actual damages that you can get back, as well as your attorney's fees. If you have no actual damages, you can receive statutory damages of up to $1,000. And again, all of your attorney's fees paid. The idea of the law is that people in these situations don't have the money for an attorney to fight back and protect their rights, and this law is in place to help them by making the debt collector or that debt buyer pay your attorney's fees. So that helps. So we want to do that. So that's our program for today. We run a little long for this month, but A lot of good information. If you've enjoyed this program, please subscribe or hit that like button down there, and tune in next month. We do these Hangouts every month. And if you have an idea for something you'd like to talk about, shoot me an email at steve@richardsonlawoffices.com, or make a comment below to this video on what you'd like to be heard talked about, or if you have a question, that sort of thing that we can deal with. Our next monthly Hangout is on Thursday, August 27th at 5 p.m. And we're going to talk about student loans and bankruptcy. I'm sure you probably heard, and the myth out there is, oh, you can't discharge student loans in bankruptcy. That is simply not true. You can. I'm not saying it's easy, but you can. There can be a heavy burden, depending upon the type of student loan. There may be other solutions available to you. But a lot's been going on lately in that area, and I'm going to talk about that next month. So if you or someone you know has student loans, a lot of student loans, and is struggling with it, we're going to talk about how do you go about determining whether you even have a shot at discharging student loans. Now, again, this is New Jersey. We're in the 3rd Federal Circuit. So not all circuits in our country, federal courts, use the same test to determine whether a student loan can be discharged. So we're talking about 3rd Circuit in New Jersey, what that test is. To get an idea of whether you even have a shot at having it discharged. We're going to talk about that next month, and maybe about a few alternatives to bankruptcy, to dealing with your federal loans. But mainly it'll be a walkthrough of the likelihood of you being able to discharge a student loan in a bankruptcy proceeding. So that's it for July 2015. Enjoy your summer. We're having a bit of hot weather here in New Jersey. Hopefully it'll cool off a little bit without too much rain. And enjoy your time off, vacation, whatever. And I'll see you on August 27th, just before Labor Day, to talk about student loans. See you.